Section 25 of Tribal Custom and Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Tribal Custom and Anglo-Saxon Law by Frederic Seebohm. Chapter 10, Anglo-Saxon Custom from the Norman Point of View. 1. Anglo-Saxon custom as applied to Normans. In approaching the question of Anglo-Saxon tribal custom, it is needful to make a clear distinction between the laws of the Kentish kings and the other Anglo-Saxon laws. The laws of the Kentish kings are known only in the MS, the Textus Rofensis, compiled or collected by Emulf, Bishop of Rochester from 1115 to 1125, and are not included in the other collections containing the laws of King Alfred and Ini. The evidence for Kentish custom seems, therefore, to be independent of that of Wessex or Mercia or Northumbria. Further, in the so-called laws of Henry I at the conclusion of the statement of the customs as to homicide in section 76, it is distinctly stated that the Virgils in Kent differed much from those of Wessex both as regards villainy and baronies. It will therefore be necessary to examine the Kentish laws separately from the others. On the whole, with regards to the others, it seems best to resort to the method of proceeding from the later to the earlier evidence, and to begin with the so-called laws of Henry I as a Norman, though unofficial view of what Anglo-Saxon custom was or had been before the conquest. It may be well to inquire first what in the view of the writer took place after the conquest, when a Norman or stranger was killed, because this at once raises the question what should happen in the unavoidable absence of kindred. See Franciagina, qui parentis non habeat murdro primitor, habeat premium natalis aegis qui murdrum abelverit. Rex dehydrete, ubi inventior 40 mark argenti, nisi intra 7 mark argenti, nisi intra 7 dies reditor, malefactor justitia regis, et talis de quo possit justitia fieri. 75.6. If a Norman, Franciagina, be murdered, who has no parentes, let that person have the price of his birth who made known the murder, the king to have 40 marks of silver from the 100 where he was found, unless within 7 days the malefactor be delivered up to the justice of the king in such a way that justice can be had of him. Ad patrem vero, non ad matrum, generation, consideratio, derogator, omnibus enim Franciaginus, et alia genus, debet esser brix pro cognitione et advocato, si penitus alium non habitat. 7. Consideration as to birth must be directed to the father, not to the mother, for the king ought to be in the place of maternal kindred, cognatia, and of advocate for the Norman or stranger if he absolutely have no other. Si ex parte patris, parentis non habeat qui occidatur, et ex parte matris habeat, quantum ad iam attiet, I tertia pars Vergildi, sui reditor. 8. If he who has killed has no parentes on his father's side, and he has on his mother's side, let what appertains to her, viz., 1/3 of his vergeld, be paid. These clauses show that when a Norman or stranger was slain, in a certain way the king was to stand in the place of the absent kindred to see that justice was done. The maternal kindred of the slain, if such were at hand, should receive the 1/3 of the vergeld which pertained to them, and so presumably the paternal kindred, if they alone were present, should take the 2/3 pertaining to them, the king taking the share of the maternal kindred. In any case, the right of the parentes was recognized when they were present. Next, with regard to the payment of the vergeld in the case of the slayer being a Norman or a stranger. Si quis hujus modi faciat homicidium, parentes aegis tantum perventit, quantum pro ea vociferant, si occidatio. 8. If anyone commit homicide of this kind, let his parentes pay so much vergeld as they would have received if he, the slayer, had been killed. Si ex parte patris parentes habeat, et ex parte matris non habeat, et hominum occideret, redant paternientes et quantum de aegis interfeciam recipient, haeduus partes vergildi sui. 9. If he, the slayer, have parentes on his father's side and not on his mother's, and kills a man, they pay for him as much as they would have received had he been killed, i.e., 2/3 of the vergeld. Sici autem paterna cogniacium, carens mali pugnit et hominum occidat, si tunc cognationem maternam habeat, reddit ipsa tertium partem veri, tertium conglitonis, pro tertia fugiat. 10. If anyone who has no paternal relations shall fight so wrongly as to kill a man, and if he has the maternal relations, they shall pay 1/3 of the whip, the conglitonis 1/3, and for the other third let him flee. Si nec maternum cognatium habeat, redding conjudonis, dimidium, verum, pro dimidia fugiat vel componat. If he has no paternal relations, the conjudonis shall pay half, and for half he shall flee or pay. Sici occidor, aegis modi secundum legum prisnum, si parentela cariat, redentur dimidium vegi, dimidium congulationibus. If any such person is killed, then according to ancient law, if he have no kindred, half shall be paid to the king and half to the conjudonis. These clauses are valuable as showing that, to meet the circumstances arriving upon the Norman conquest, there was a recurrence as far as possible to ancient law and Anglo-Saxon custom. This was not the first time that the difficulty of absence of kindred had occurred and been formally recognized in England. The early Danish conquests had made special provisions necessary for the protection of the kinless stranger, and it was declared that, if anyone did wrong to an ecclesiastic or a foreigner, as to money or as to life, then should the king or the earl there in the land and the bishop of the people be unto him in the place of a kinsman and of a protector, for Moic and for Mundbaron, unless he had another. Again, as regards the position of the maternal relations and the conglitonis of a stranger, it is clear that the writer of these so-called laws is copying and adopting what he finds in the laws of King Alfred, in sections 27 and 28 of the latter. In the absence of relatives, the gegildes of the slayer were to pay half the vergeld, and also in the absence of relatives of the slain person, his gegildes were to receive half the vergeld. In both cases, an artificial group of organized comrades, gegildes or congildones, seems to have been recognized as in part taking the place of kindred, and the importance of the provision of some such substitute for protection by the oaths of kinsmen is evident enough when it is considered that the ordeal of hot iron or water was the recognized alternative. On the whole, the clauses in these so-called laws relating to Normans and strangers adhere to the principle of the liability of kindred, both paternal and maternal, in cases of homicide. And this is the more remarkable because long before, especially in the laws of Edmund, as will hereafter appear, a very strong tendency had been shown to restrict the liability in case of homicide to the slayer himself. In the meantime, the attempt to apply the Anglo-Saxon custom as to vergelds to Normans after the conquest, taken together with the continued recognition of the liability of both paternal and maternal parentes, is a very strong proof that the solidarity of the kindred was not altogether a thing of the past. Tribal custom, which at the Norman conquest could be applied to the conquering class, cannot be regarded as dead. 2. Norman view of Wessex custom. We pass on now to Clause 70 of the Laws of Henry I, with the heading Consuetudo Wessexa. The amount of the vergeld according to Wessex law is thus stated. In Wessexa, qui caput regni est et legum, twihindi 1 viliani, vera est 4 lib, 12 hindi, 1 theni 25 lib. 71. In Wessex, which is the capital of the kingdom of laws, the were of the twindelhindum, i.e. of the villainous, is 4 pounds, of the 12 hindinum, i.e. of the thane, 25 pounds. The Anglo-Saxon and Norman pound of silver was 240 pence, and thus the 12 hindimans vergeld of 25 pounds was the same thing as the ancient Wessex vergeld of 1200 Wessex shillings of 5 pence. 4 pounds was a rough equivalent of the twi-hindiman vergeld of 200 Wessex shillings. A little further on in the same clause is the following quotation from Ethelred II's compact with Olaf. Si Anglias homo dacum occidat, liber liberum, persilavat eam 25 lib vel ipsi malefactor retitor, et tandidum retit darkis de Anglico si eam occidat. 70. Section 6. If an Englishman kill a Dane, a freeman, let him pay for him 25 pounds, or the criminal himself shall be delivered up, and let the Dane do the same if he kill an Englishman. The English and Danish typical freeman of this clause, with his 25-pound vergeld, is clearly recognized in these so-called laws as the 12 hindeman, and not the twill hind man, who, though free, is identified with the villainous. In further sections of this clause regarding Wessex customs, very important statements are made with regard to the position of the wife in case of homicide, showing 1. That if she committed the homicide, her own kindred were responsible for her crime, and not her husband or his kindred, and 2. That in case of the murder of a wife, the vergeld went to her kindred, and not to the husband or his kindred. In section 12 of this clause is the following statement. Similitur, si nullia homicidium faciat, in eam vel in progenium, vel parentis aegis vendricultur, vel indi componat, non in virum suum, si clientelum innocententem. Likewise, if a woman commits homicide, let it be avenged on her, or on her children or parentes, or paid for from that side, not on her husband or innocent connections. And in section 13, si mulier occidator, sicut verigildum, aegis et retitor, et parte patris, sicut observanus in alias. 14. Si pregnans occidator, et pura et ea vivat, uterque plena vera retitor, si nondum vivus sit, dimidia vera solvitur parentibus et parte patris. If a woman be killed, whatever be her vergeld, let it be paid ex parte patris, just as we have said in other cases. 14. If a pregnant woman be killed and her child be living, let the full vergeld of both be paid. If not yet living, let half a vergeld be paid for it, to the parentis et parte patris of the child. The position of the wife under Wessex custom is further shown by the following. Si sponsa virum suum superfixiet, dotum et maritationem suum, caterum, instrumentis vel testium exhibitionius, e traditum, perpetualiter habeat, et morgengivum suum et tertium partem de omni collaborationem sua, preter vestis et litem suum, et si quid ex ius in alimonius vel communi necessitati consumpserit, nihil indi recipipat. Sections 22 to 23. If the wife survive her husband, let her have permanently her dower and her maritagium, given to her by written instruments in production of witnesses, and her morgan gift, and a third part of all joint acquisition, besides clothes and her bed, and let her receive nothing in respect of what has been consumed in charity or common necessity. Simulia absci liberis moriator, parentis aegis cum marito, sua partum suum dividant. If a woman die without children, her parentes divide her share with the husband. These statements are valuable evidence that, in regard to the position of a wife, Anglo-Saxon custom was very nearly the same as Cymric custom, and that of the Brets and Scots, and they are the more important as stating, in black and white, what is only to be inferred from isolated statements in earlier laws. We now pass to C. 76, Deprecio Cogilibet, containing information as to the mode of procedure in the payment of vergeld. After stating that if a man be slain, he is to be paid for according to his birth, the clause proceeds thus: et rectum est et homicidi, postquam verigidum, patia verit inveniat, vera plegios, sicut et eam pertinevit. 1. De thano de brent dari 12 vera plegi. 8. De parti patris. Et 4. De congiationis matris. Et cum hoc factum erit, elevetur inter ius pax regis in omni verigildo, et debet havsang primo rete, sicut veri modus erit. And it is right that the homicide, after having given pledge for the vergeld, should find the ver pledges pertaining to it. From the thane, 12 ver pledges, 8 ex parte patris, and 4 de cognitione matris. And this done shall be raised among them the peace of the king in every vergeld. And first the half-sang should be paid according to the nature of the vergeld. Following the case of the 12 hindermen a little further, we learn that 12 hinders et homi plenus nobilis, 1 thanes cluges vera et 2 decies, si sol qui faciantus libris 25. Cluges half-sang sunt 120, sol qui faciant oldi sol 1, et non pertiat alii cognitione, pecunia ista, nisi illis qui sunt intra geni. The 12 hinderman is the man pleni nobilis, i.e. the thane whose vergeld is 1200 skillings, which makes up 25 L. His half-sang is 120 S, which today equals 50 S. Norman, and it belongs to no other relation than those who are intragenu. This half-sang had to be paid on the 21st day from the giving of the pledge, and it seems to have been a token in recognition of guilt or earnest money to show that the vergeld would be paid. On the next 21st night from the payment of the half-sang, the man bought had to be paid, and on the 21st night after that, the fight wife, and on the 21st night again the first payment of the vergeld. Et sic omnibus parentibus dominisque emendationibus insidiatus persolvantur reliquum veri inter terminum quem sapientis instituent. Thus for all the parentes and lords, amends being set a-going. The rest of the vergeld shall be paid during a term to be fixed by the wise men, sapientes. Turning next to the case of persons twinhold born, Serlisci vel Villani, more details are given. After stating their vergeld to be 4 pounds, the clause proceeds. Half-sang, aegis sunt 5 mark, qui funciat 12 sol, et vid den, est autem verbum Anglicum quod Latini sonat apprentiatio coli. They have saying in 5 marks, which equals 12 shillings 6 pence, and it is an English word which in Latin means apprehensio coli. There is evidently here an error. 5 mark ought to be read 5 mancuses. The mancus was 30 pence, or 2 shillings 6 pence. Norman money in the half-cent, therefore, 150 pence, or 12 shillings 6 pence. Norman money is stated in the following clause. Sici ad forlib per solvendis occidator, et ad it res veniat, ad Persia naturalis aegis capendus sit, primo debent, ready 12 sol, et 6 den, et in vera numerari, redadantur vero patri, vel filio, vel frati, vel qui propendicior, est di patri, si predictos parentes non habeat, si omnes isto habeat, et ipsi dividant inter se. 6. If anyone is killed to be paid for, at 4L, and it comes to pass that the price of his birth has to be paid, first should be paid the half-sang of 12 shillings 6 pence, to be reckoned in the vergeld, and this is to be paid to the father or son or brother, or failing these, whoever is the nearest of kin to the father. If he has all these, they divide it between them. Ad die qua vera fatiata est in 21 diem, sin omni excusatione et dilatione, debit half-sang ready, sicut permissimus. On the 21st day from the giving of the pledge, without any excuse or delay, the half-sang shall be paid, as we have said. Indi ad 21 diem ratator ipsius mandopa, tunc ad 21 diem put vita. Indi ad 21 diem redadantur ipsius via prumgildum, 1/7 sol, et 6 den, ad applicationem 20 sol. On the 21st day after that is to be paid the monbot, then on the 21st day the fig white, and then on the 21st day must be paid the frumgeld of the vergeld, i.e. 7 shillings 6 pence, to the completion of 20 shillings. Thus we learn that in the case of the Twihunderman, the half-sang of 12 shillings 6 pence and the frumgeld of 7 shillings 6 pence make up the first 20 shillings of the vergeld of 4 pounds. The clause proceeds, indi carponet qui verum solvit, terminum di 20 sol, indi ponet terminum suum parentes mortem di 40 avibus, qui pro 20 sol, caponitur, sint ovum ovis videntes et canuti, nulla parta corporis diminuti, ultima termino redditor equius, qui pro 20 sol, numerandus est, hoc secundum legum et nostrum consuetudinem diximus, differentia tamen verigildi, multa est incantia villarorum et baronum. After that, who pays the vergeld pays at another term 20 shillings. Then the parentes of the dead fix a term for 40 sheep, which are reckoned as 20 shillings, but they must be sheep, seeing and horned and deficient in no part of the body. At the last term, a horse is given, reckoned at 20 shillings. This we have said according to law and our custom. There is, however, great difference in the vergeld of both villani and barones in Kent. Thus, both in the case of the 12 Hindi and the Twihunderman, the half-sang is the first beginning of the vergeld, and whatever may be the exact meaning of the word, it is pretty evident that it was regarded as an admission of the wrong done, and as a kind of earnest money that the rest of the vergeld would be paid. But between the half-sang, or earnest money, and the making up of the first full installment of the vergeld were the 2 other payments, the manbot and the fight weight. They have already been mentioned, but it is important to recognize what these two payments outside the vergeld mean. We learn from c. 80, section 6, what the fight weight was. In contra cumsi terra fiat homicidium, qui socium et sacum suum habeat, si homicida deviatio ibi vel crevitur, fivitum sifiat, si occusus et locus unius domini sint, qui socium suum habeant manabatum et vituum. On whatsoever land the homicide may be committed, he who has sock and sack shall, if the homicide there be pledged or remanded, receive fight weight. If the person killed in the place are of one lord, let him who has the sock have both man-bought and fight weight. It is clear from this that the fight weight was the payment due to the lord who had the sock of the place when the homicide occurred and the vergeld was pledged. The man-bought, on the other hand, was the payment to the lord whose man the person slain was. The lord of the sock might also be the lord of the man slain, in which case both fight weight and man-bought were payable to him. In c. 69, the man-bought of the twy hindermen is stated to be 30 shillings of 5 pence, i.e. 150 pence, and that of the 12 hindermen 120 shillings, 600 pence, as in the laws of Inni, section 70. In the so-called laws of Edward the Confessor, c. 12, is the following. Qui sentia figurat eam pacem regus, lege ad glorum suum ver, one precium suum, et manbot, de auxias ergo dominus quorum hominis intefecti erant, manboti in dalilaga, de villanel, et de shoman, 12 ores, de libris hominibus 3 marcus, manboti, in lege ad glorum, regi et acies piscopo, 3 marc de hominis sui, episcopo comitatus, committee comitatus, et defragus rigus 20 sol, baronabis ceteris 10 solid, emendationum faciet parentibus, ad gerum presiatur, undi Angli proverbium habebant, pies speri, of siti oda beer, quod si desiri, lancium emi de lati aut veram. He who knowingly breaks the king's peace by the law of the English pays his ver, i.e. precium suum, and man-bought of persons killed to the lords whose men have been killed, man-boughty in danalaga of villainous, and succumum 12 ores, of liberis hominis 3 marks, man-bought in English law to the king and archbishop 3 marks for their men, to the bishop and earl of a county, and dapper of the king 20 shillings, other barons 10 shillings. Let him make amends to the parentes or suffer feud. Hence the English have a proverb, buy off the spear or bear it. This chapter chiefly relates to the breach of the king's peace on the king's highways, etc., but it clearly confirms the meaning of the man-bought as the payment to the lord for his man, and is quite distinct from the vergeld to the parentes of the slain. It may seem strange at first sight that according to this clause, the man-bought in the danalega of the villainous and the sockman should be alike, viz. 12 ores of silver, and further that the villainous and the sockman should not be included as liberi hominis, the man-bought of the latter being double their man-bought, viz. 3 marks or 24 ores. The explanation of the equal man-bought of villainy and sockman may partly be found in the tendency after the conquest to class together all subordinate tenants, rendering manual or agricultural services to the landlord as villainy, and to ignore the differences in origin between the various classes of tenants of this kind. Still, if at this point of our inquiry the relative positions of the sockmani of the Danish districts and the villainy of the ordinary English manners were the question under discussion, it would be fair in explanation of the equality of the man-bought to point out how very nearly the services of the two classes seem to have corresponded so far as to their value to the lord was concerned. The loss to the lord of the 12 hintermen was probably reckoned as of greater money value than that of the villainous or sockerman, because of the higher grade or character of his military and judicial services, as compared with the agricultural services of the villainous and sockerman. However this may be, these considerations confirm the importance of the distinction between the man-bought, which varies according to the value or loss to the lord of the person slain, and is therefore payable to him, and the vergeld payable to the parentes of the person slain, which varied according to the grade and social rank in which he was born, or to which he may have sometimes risen. Further, this distinction between the vergeld and the man-bought becomes all the clearer when we turn to the evidence given to the laws of Henry I regarding the custom of Wessex in respect of the homicide of slaves. In c. 70, the custom of Wessex is stated thus: Si servus servivem occidat, domino rotato 20 sol, pro man-bouta, parentibus interfecti servi 40 den. Section 2. If a slave service kills a slave, 20 shillings, question of 5 pence, is paid to the lord for man-bought. To the parentes of the dead slave, 40 pence. Si dominus auxioris, nec pro eo reddit, nec servis habet undi reddit, demeritari potest eam dominus, et sibi caveat, nisi forte cravator dum sectum est, quod si evianit, eam repentibus reddit vel indi componat. Section 3. If the lord of the slave pays nothing for him, and the slave has nothing to pay with, the lord can dismiss him so that he, the lord, may protect himself from having the slave seized while with him. But if this happen, he shall hand him over to the prosecutors, or pay for him. Si liber servum occidat, simulator reddit, parentibus 40 den, et duas muflas, et unum pullum mutilatum, domini servi 20 sol, pro man-bouta blot vitam, vet 20 facum, sicut acceritit. If a freeman kills a slave, let him likewise pay to the parentes 40 pence and 2 muffles, and a capon. To the lord of the slave 20 shillings, a 5 pence, for man-bought also, blood white or fight white, as it happens. Si servus Walliscus, Anglicum hominum occidat, debit illi cugus, servus et redere eam domini et parentibus, vel dari 40 sol, pro vita sua, si hoc capitula, nollit dari pro eo, damatat eam liberum, solvent postea parentes aegis verum illum, si cognationem habeat liberum, si non habeat, observant eam inimici, non cogitur liber cum servo meglidari, nisi velit satisfactionem facere, nec servis cum libero. If a slave Walliscus kills an Englishman, he whose slave he is ought to give him up to the lord and the parentes, or pay 40 shillings, of 5 pence, for his life. If he does not choose to pay this for his head, let him set him free. Then afterwards, let his parentes pay his vergeld if he has free relations. If not, let them regard him as an enemy. No freeman is to be compelled to join in payment with the slave unless he wishes to make satisfaction for him, nor a slave with the freeman. Thus, while under the Dana Laga, the equal man-bought of the villainous and of the sockerman was 12 ories of 240 pence, we learn from these clauses that the man-bought of the ordinary slave under Wessex custom was 20 shillings, i.e., if of 5 pence, 100 pence, while that of the twi hintermen was, as we have seen, only 150 pence. At first sight it may seem strange that the man bought of value to the lord of his villainous or sockman should be no greater, or even less, than that of his theo or slave. But a moment's consideration will show that the value of the villainous and the sockman to the lord was mainly their week work and services amounting to, perhaps, half their whole time, while that of the slave or theo was the value of his whole time and also that of a marketable chattel. It may be noticed, too, how in the statements of Wessex customs some slight recognition is made of the kindred of the slave, but the amount, 40 pence, is so very small that it hardly can be reckoned as any real approach to recognition of family rights or rights of kindred belonging to the relatives of the slave. In the laws of William the Conqueror, the man bought of the slave is stated, perhaps in error, to be twice that of the freeman, and in the case of freemen a concession is made of 12 shillings of the vergeld to the widow of the slain, who otherwise, not being of the same blood or kindred with her husband, would under tribal custom have received no part of the vergeld. Si quis convictus vel confessus furiat injuri, alium auxidisi, dat versuum, et in super domini auxius, manbot, scillatit, pro homini libera 10 sol, pro serva 20 solid. Section 7. If anyone shall have been convicted of or have confessed the slaying of another, let him give his vergeld and over and above to the lord of the person slain, man body, that is, for a freeman, 10 shillings, a 5 pence or 12 pence, for his service 20 shillings. Et autem verdini in mercillaneni 20 libra, in vexale celea 25 libra, vertici autem si solidi, in mercillaneni, et simulator in vexat solidi. 8. The vergeld, however, of the thane under Mercian law is 20 pounds, i.e., 1200 shillings of 4 pence. Under West Saxon law, 25 pounds, i.e., 1200 shillings of 5 pence. Other rustic sees, of 5 pence or 12 pence in Mercia, and the same in Wessex. Divera ergo pro ossico, saluto, primo virtu 10 solidi, dentur et residium liberi et consagliarni inter se diffidant. 9. Of the vergeld thus paid for the slain person, first let 10 shillings be given to the widow, and the rest let the children and relations divide between them. Finally, it is interesting to observe that according to the so-called laws of Henry I, tribal custom was still partly recognized in the method of dealing with the homicide of a kinsman. In clause 75 is the following: Qui alicem de parentibus suis occidit, dignus apud Deum, penitentii fugitivus emendat, et in modo penitentii sit, si sponto vel casu perpetravit, et excedet emendatio patrini, sicut manbato domini, si non pentiat et utricum, et aliorum importurati, quorum sanguineus est, cogitur eam rederi, sapiatum hoc judicio, secundum genus componitor. He who shall slay any one of his parentes, let him make amends by fruits of penitence worthy before God, and let the measure of the penance be according to whether he did it willingly or by accident, and the connection of the sponsor falls just, as the man bought of the Lord. If it does not permit to him either the one or the other, and by the importunity of others, whose kinsman he is, he shall be compelled to pay. Let it be compounded for, by judgment of wise men, whatever that may be. The homicide of a kinsman was apparently still generally free from judicial interference or criminal law. The slayer is handed over to the church, and his punishment is spiritual penance. Even the man bought to the Lord, who has lost a man through his crime, fails to be paid. But should there be a fear of trouble, through the importunity of any of the kinsmen of the slain, demanding compensation, then a compromise was to be effected by reference to the judgment of wise men. Tribal feeling is evidently not yet dead, although beginning in this matter to yield to the more modern view of individual responsibility for crime, without regard to the question of kindred. There is at the same time recognition of the fact that the weakened tribal feeling is no longer always able to restrain the kinsman from revenge in the case of wrong done within the kindred. End of section 25.